is on. And we'll get started here momentarily, just giving folks a chance to join. All right, it's 4 after the hour, so we'll get started. Thank you everyone so much for joining this morning or this afternoon, depending on what time zone you're in. Thanks for joining. Today we're going to be talking about so-called dark patterns and manipulative user interface and UX design and the role of regulation in this space. I'm Stacey Gray. I'm a senior counsel here at the Future of Privacy Forum, and I'll be your host and your moderator, and we'll do introductions momentarily. First, a quick word about FPF for those of you who are just joining us or might not be familiar. FPF is a Washington, D.C. based nonprofit organization focused solely on consumer privacy regulation and consumer privacy generally, with a particular focus on emerging technologies. And although we're based in DC, we actually work on consumer privacy here in the United States and globally. Today, we have a pretty full agenda for you. I'll give everyone a heads up that we're going to be running from 12 o'clock to 1:30 p.m. Eastern time, or 9 to 10:30 a.m. Pacific time if you're joining us from the West Coast, as some of our speakers are. I'm going to do a quick introduction about why we're talking about this topic today, a brief look at some of the legislative proposals we've seen out there, and then I'm going to introduce our main guest speaker, Dr. Jennifer King, to talk about dark patterns. What are they? How do they work? What are some examples of them? And we're going to, towards the top of the hour, have a really excellent discussion with some panelists that we've invited, Mihirik Shirsegar and Tanya Forsythe, who I'll introduce later on in the hour. And I'd invite you folks, actually, if you like to stay on camera or to turn it off, up to you during the main presentation. This is our agenda for today. As a final reminder, of course, we are recording today's webinar, so we will be posting it along with the slides on our YouTube channel, which you can find via fpf.org within usually about a week. So you can find a recording of today's presentation. We will also be doing a robust Q&A and would invite your participation. So we have the chat disabled this afternoon, but we are doing Q&A through the Q&A feature on Zoom. So you can post questions throughout and or at the end. And of course, we'll also be doing a little poll for some audience participation later on. So stay tuned for that. All right, so to start us off, I wanted to just give a quick introduction about why are we talking about this? Why are we talking about this now? You've probably seen the phrase dark patterns in the news if you're following commercial privacy issues closely or following the policy evolution in this space. The phrase has been around, of course, for quite some time, which Dr. King is going to talk about and we'll discuss. But in recent years, we've seen a large number of serious legislative proposals in the United States addressing comprehensive consumer privacy issues. And as part of that, we've begun to see the phrase dark patterns and the concept generally of manipulative design appear in US privacy regulations, FTC enforcement actions, and legislative proposals at the federal and the state level. So we're going to return to this at the end of the hour to talk more, maybe go a little deeper into some of the legislation. But for just now, I'll note for those who haven't been following, two major events of the past few years have been the passage of the California Consumer Privacy Act and the passage of the California Privacy Rights Act in 2020, the CCPA and the CPRA, which amends it. The regulations passed by the Attorney General in California under the CCPA actually have a narrow requirement that dark patterns not be employed in the California opt-out of sale method that companies are required to provide. So opt-out methods that are designed with the purpose or substantial effect of subverting or impairing a consumer's choice to opt out are prohibited under the Attorney General regulations. The CPRA goes further, and for the parts of the CPRA that actually require affirmative consent, such as the sale of information from children, or such as opting into data collection or use after you've opted out or expressed a preference to opt out, dark patterns are explicitly prohibited in the text of the CPRA. Defined here somewhat differently, as we can talk about, as a user interface with the substantial effect of subverting or impairing user autonomy, decision-making, or choice. Okay, so we can return to that. Another significant factor in the last few years has been the increase in legislative proposals that also explicitly define or create requirements around dark patterns. So here are just a few. These are not laws that have passed or become law yet, but are just legislative proposals. So the Washington Privacy Act in the state of Washington, which is pending right now before the Washington state legislature, would completely prohibit the use of a dark pattern in that bill's requirement of affirmative consent for the collection or use of sensitive data. You see it similarly show up in sectoral state bills. California SB 980 last year was a bill regulating genetic information, the collection and use of genetic information. And you see it at the federal level. So the Safe Data Act, which was one of the two leading consumer privacy proposals in the United States Senate, introduced by then Chairman Wicker, the Republican chairman of the Senate Commerce Committee, would have prohibited conduct that, although it doesn't specifically say dark patterns, essentially amounts to dark patterns. So conduct that manipulates a user interface with the purpose or effect of obscuring, subverting, or impairing user autonomy, decision-making, or choice to obtain consent. So major public policy issue, major focus of lawmakers across the United States. Worth noting that this is also an ongoing focus of the Federal Trade Commission, of course. On April 29th, 2021, just in roughly a month, the FTC will be hosting a workshop called Bringing Dark Patterns to Light, where they will explore this issue. We know this has been an ongoing focus of the Federal Trade Commission because of some of the language and some of the statements that we've seen from previous FTC commissioners around FTC enforcement actions that involved manipulative or deceptive user choice interfaces. And that makes total sense because the Federal Trade Commission is, of course, our #1 federal consumer protection body. It enforces the FTC Act, which bans deceptive or unfair commercial practices. So we know this is a major federal issue as well. So I will stop there. We have a great presentation today, not on the law, but on the tech and the design elements of dark patterns. And then we'll get back into a discussion of all of the above, law, policy, tech, at the end of the hour. So please put your questions in the chat. I'm sorry, put your questions in the Q&A to interact, and we'll be addressing them throughout the hour. So with all of that, let me introduce our guest speaker. Dr. Jen King is a Privacy and Data Policy Fellow at Stanford Institute for Human-Centered Artificial Intelligence. We're going to switch over to Jen's slide here. Awesome. Dr. King is a privacy scholar and a researcher. Many of you may already be familiar with her work. She has a PhD in information science and human-computer interaction and has spent 10+ years thinking and examining dark patterns in practice as an expert witness with the FTC in the States. And in particular, I don't know whether we'll get too deep into this, Jen, but I think people should know about your upcoming paper being published in April in the Georgetown Tech Law Review called Regulating Privacy Dark Patterns in Practice, and specifically getting into the California Privacy Rights Act. So very cool paper. People should look forward to it and read it as soon as it's available. Jen, let me hand things over to you to tell us more about dark patterns.
Great, thank you. Can you hear me okay? Great, all right. So good morning from California and good afternoon to the rest of you. As Stacy said, I'm Dr. Jen King. I'm currently the Privacy and Data Policy Fellow at the Stanford Institute for Human-Centered Artificial Intelligence. And I have been working in this field for about 10 years, specifically on dark patterns. I'm a privacy scholar and researcher, but not being a lawyer, my background's in information science and human-computer interaction. I've brought that experience to bear on a number of cases by the FTC and others looking at dark patterns actually in practice. And so just a quick recap of what we're going to talk about today. Stacy already gave you the intro. I'm going to go through and really explain like what are dark patterns, talk about a few definitions, talk about the contexts that they target, review how they work. You know, how do these things become so effective? We'll go through some types of dark patterns, walk through some examples, which is always the fun part of the presentation. And then I'll close with some key thoughts for policymakers for regulating this space. And then we'll move into our discussion and Q&A with the whole group of us. Okay, so first off, let's start, what is a design pattern? So we hear the word dark patterns. What's the pattern part of that? And so a design pattern is basically a building block for a user interface. They're the components that designers use. And when I say designers, I want to just clarify, it's more of a proxy. I mean, we are talking about literal designers, the people who build interfaces. But when we talk about designers and definitions, that's also a proxy for kind of anybody who's in control of the design process. So this could be a company and not just an individual person. But anyway, so the design patterns themselves are these building blocks that designers use to build user interfaces. And so the example I've given here is the design pattern for refreshing a screen on a mobile device. And these aren't exactly standards. We don't really have a standards body per se in the kind of usability UX design space that issue standards, but these are more things that have accumulated through experience or through practitioner experience. And there's kind of an informal, I would say, almost agreement or academic publishing potentially that helps people refine in the space kind of what works or what is more usable than not. And so when we talk about dark patterns, we mean something very specific. And so Harry Brignall, who is a practitioner in the space, first coined this definition back in 2009. So again, they've been around for a while. It's just that they've become more and more popular, and we'll discuss why as we go on. But he called dark patterns a user interface that has been carefully crafted to trick users into doing things. They are not mistakes. They are carefully crafted with a solid understanding of human psychology, and they do not have the user's best interests in mind. So Harry Brignall really introduced this concept, I think, to kind of the public per se. But I think it's important to understand that this area is still very much in flux. The CPRA has a very specific definition that we'll also talk about towards the end of this presentation. But really, this is an area that, even though it's been emergent for the last 10 years from the kind of design community standpoint, there's not a single definition that kind of everybody has agreed on for dark patterns. And so I have another one here from Liguri and Strahilowicz as an example. But I want to talk specifically about one that one of my co-speakers today helped develop. So this is a definition that Aranesh Mathur, Jonathan Mayer, and Mihir Shasigar defined in a recent paper that's actually being published in the next couple months. Dark patterns are a user interface design choices that benefit an online service by coercing, manipulating, or deceiving users into making unintended and potentially harmful decisions. And one of the things I really appreciate about this definition in particular is that it isn't focused on the intent of the designer. There's been a lot of kind of discussion of that intent in the design space. And I think from a policy standpoint, one of the takeaways I hope you come away with today is that we need to move away from the intent of the designer, because what really matters is the effect of dark patterns. What's actually happening on the ground? What is the outcome of their use? And so intent, as if you know in the policy space, is a very difficult thing to try to prove. And so it also leaves it open to instances where a dark pattern has this effect, but it wasn't necessarily intended to. So for the most part, these things are not accidental, but it also leaves open for the possibility that you could have something that wasn't necessarily intended to deceive, manipulate, coerce, but ends up having that actual effect. And I should note the animation on the screen is not real, but just to give you an example of a very frustrating kind of example of a dark pattern, the unsubscribe button that you perpetually try to click and then you can't actually click it. Okay, so where do we find dark patterns? What contexts are we finding them at this point? So in general, there are three primary areas that we're seeing them today, but this isn't necessarily exhaustive. We may see them in other places as they continue to develop. So one is e-commerce, primarily online shopping. The next is in the privacy space. So dark patterns focused on disclosure and consent. So essentially trying to get you to reveal more information than you may have been comfortable doing so. And then also there's been a focus on what I think of as attention dark patterns, or even addictive dark patterns. Although I'm very careful with the word addiction, because it's an area that I think we haven't seen kind of the addiction community, the experts in that field really weigh in on. but those are ones that are really focused on trying to draw your attention. And in that sense, we often see them in the gaming space. Some of the legislation that's been proposed at the federal level has been concerned about addictive dark patterns and the idea that they monopolize your attention and make it very difficult for you to pull away from things. This is a large concern with children, for example. But for the most part today, I'm going to focus on privacy dark patterns, but we really have seen the bulk of them in the privacy and really the e-commerce space. And so where you find those typically are at decision points. So places where an individual needs to make a decision or actually execute an action. And that's where we see people are the most open to being coerced or manipulated or deceived. And there's some interesting kind of, I think, analogs to this in the real world where, at least here in California, we have consumer protection laws where, if you are making a very high stakes decision, like signing off on a mortgage or buying a car, you essentially have a cooling off period where you can change your mind. Because there's a recognition that sometimes not only do people make these decisions under duress or under high pressure sales tactics, but they're such high stakes decisions that they allow you kind of the space to reconsider. And that's something I think that we should keep in mind, depending on kind of how serious the decision-making capacity is when we engage with people online. Okay, excuse me. So one of the key questions that I've brought to this space as I think about it are really, what are the limits of permissible persuasion? So at what point do we go from persuading people to actually engaging in something that's coercive or manipulative or deceptive? And so the point I want to make here is that this has been a concern for actually quite a long time. And so some of you may be familiar with The Hidden Persuaders. It's a book that was published back in 1957. And so that's by Vance Packard. And he was extremely focused on these questions of, are advertising companies manipulating us? Are they doing things to us that we can't quite perceive? More recently, in the 1990s, we saw the work of Robert Cialdini. Cialdini is a former academic turned consultant. And he works in the field of consumer psychology, and he did a lot of work in really decomposing what makes persuasion persuadable. And I encourage you to look at his work. His book, Influence, which is the picture I have here, is really a classic, and it really kind of decomposes exactly how persuasion works. And it's actually a really good read. Okay, but more recently, so those are some of the foundations. How do they work in practice? Like where have they come from in the last decade or so? And so the key thing to understand is that dark patterns are effective because they work on our cognitive biases and the heuristics we use. So basically, what are these things? So cognitive biases are kind of systematic errors in our thinking. They're things that humans in general make mistakes as we reason in our capacity to think. And so I've listed a few here. I'm not going to go through them. You're welcome, of course, to go and look them up on your own. But the idea is that we have flaws in the way we think things through and the judgments we make. And dark patterns are especially good at optimizing for those flaws in our thinking and taking advantage of them. And so some of the ways that we've seen them develop over the last 15 plus years really started with the work of B.J. Fogg, who is also at Stanford. And he started this field of persuasive design, which he called captology, which is really the study of how interactive computing products, computers, phones, websites, and so on, can be used to change attitudes or behaviors. And then we saw some of that work that rests on the work of researchers like Daniel Kahneman, who's in the behavioral economics field. He and his research partner, Amos Tversky, Kahneman won the Nobel Prize for his work in this area, but they really did the kind of first systematic studies of how people make decisions and how biases and heuristics affect how we make decisions. More recently, we've seen the work of Richard Thaler, also a Nobel Prize winner in economics, and Cass Sunstein, in kind of rethinking this work into nudges. And so nudges are a way of trying to change behavior, but the focus generally has been on overcoming these biases and heuristics to make positive changes in people's behavior. And one of the classic examples they provide is how most people aren't incentivized to save for retirement. So one of the classic nudges they've introduced is the idea of auto-enrolling people in 401k plans and allowing you to opt out rather than opt in, because most people won't opt in. But the idea is saving for retirement over the long term is obviously in your best interest. And so these are ways to kind of like nudge you into making a decision that should benefit you. Dark patterns essentially here are then the opposite. decisions that don't benefit you, but benefit the person who's making the design. And so we see these not just in the design space or the online space, but we also see these in the real world. And so the picture I have on this slide is what's called a planogram. And so this is what we see in the commercial supermarket space. And so I think that's an excellent example of how we see design, consumer psychology, and to some extent, dark patterns kind of all come together in the physical world. And so it's also a really good kind of example in thinking through at what point do we cross the line from persuading people to actually coercing them or manipulating them. So in the modern supermarket, there is essentially nothing left to chance. And I mean, big commercial supermarkets, not your mom and pop store. But essentially, there is a whole network of actors in this space that have spent the time trying to understand what will make you buy, more groceries, more products when you're in the grocery store. And so, the classic example here is that the staples that you usually need, the milk, the bread, and the eggs, are always at the back of the store, and they force you to kind of wander through and be, open to potential upsells as you walk through the store. And this is such a concern that in my town where I live, Berkeley, we actually have a law going into effect this month that bans the use of junk food at checkout aisles. And so Berkeley is concerned enough that these effects are real enough in the real world that they need to actually control what goes on at the checkout stands. And so in Berkeley now, if you come here, you'll only see, in theory, fresh fruits, vegetables, healthy snacks, no more gum, chewing gum, sodas, and candy. But I think one of the interesting questions this brings up is this distinction between the physical and the digital. In this physical world, one of the things that we're seeing here is that, yes, there's all these forces at work trying to get you to buy things in the store, but when you leave the store, you're not likely to have something put into your shopping cart or your actual basket or your bag when you leave the store that you didn't put in there yourself. So yes, you were potentially influenced to pick up things as you went in the store and you left with more than you bargained for, but no one actually forced you into buying groceries that you didn't want. And that is, I think, one of the lines we see in the digital space is that we're actually seeing instances where people are ending up going through a checkout, for example, with items they didn't intend to buy, or they find themselves enrolled in a monthly program that they did not actually that they didn't even know they were enrolled in. And so that's one of the areas that I see with dark patterns is it's not so much just the hard sell and the persuasion, but it's the actual interfering with your choice and what you're trying to do. Okay, so how did we get here? How did dark patterns begin to take rise in the digital world over the last decade? And so really one of the key factors has been what we call A/B testing and the ability to do this at scale. And so A/B testing is actually a very simple experimental method. And essentially, the slide I give you kind of gives you a visual example of this. So in the web design context, you can create two UIs, and maybe they differ on one factor. They differ on the color. They differ on what images are being used. You can very tightly control the differences, put them out in front of people, and then essentially test to see which ones drive up the metric that you're looking for. Online, it's often conversions, whether someone clicks, whether someone makes a purchase. And so what A/B testing at scale, at really, really large sizes has been able to do is open up that refinement to the point where companies can run thousands, literally thousands of these experiments every day and really, really work to hone not just the messaging, but kind of what about the design of their sites makes it more persuasive for people and potentially cross that line into dark patterns. But because of this capacity, prior to being able to do these things at scale, researchers like myself might have to go into a lab and recruit participants, and you can do these things at a small scale, but not on the magnitude of millions and millions of participants, which is what I'm talking about here. And this allows you kind of a tremendous capacity to really understand what moves the needle in terms of what makes people cross the line into sitting off on the side and actually engaging and buying, clicking, or whatever it might be that you're trying to optimize for. Okay, so we'll get to examples very quickly, but just a couple things before we do. So first, types of dark patterns. And so again, I'm drawing from the work of my colleagues at Princeton, Arnesh Mathur and his colleagues, and trying to examine like what types of dark patterns are we seeing out there. And so they, again, I think did a tremendous job in reviewing the literature and coming up with these different categories of what types of dark patterns we see. And so, but I think one of the really interesting insights they had is when you look across these, so if you look at the first three definitions, we have asymmetric dark patterns, things that emphasize one thing over another. We have covert ones where you're being steered towards something without your knowledge. And you have restrictive dark patterns, which limit the number of choices we have. So all of these things work to modify what's called the decision space. So your range of possible options. So these are things that basically make it difficult for you to accomplish something or give you fewer options than you might like. I think a classic example of that is in the consent process, when essentially it's either agree or leave. There's no intermediate option there. There's no option to bargain. It's just either, take the terms we offer you or go. The other two, the information hiding and deception, those manipulate the flow of information. So it's not about constraining the choices, but it's more about controlling what information actually reaches you online. And so does the dark pattern isn't one that tries to hide information to make things less apparent. We see this a lot with disclosures, for example, that companies may have a disclosure, but they'll hide it in plain sight, which is something I've worked on repeatedly in my work. Where do people put those links? Where are the California do not sell my personal information links, for example? We never find those at the top of the page. We often find them very much at the bottom in very small print. Deception, are we actually planting false beliefs? Are we misleading people? Are we just saying things that aren't true? And so I found this framework very helpful in trying to think through and what the dark patterns are, how they work, and what types and categories they fall into. All right. And so before we go through some examples, I want to just dive a little bit deeper into the differences between persuasion, deception, coercion, and manipulation, because I think this is a really key area for understanding how they work and what's wrong with them. And so we've talked a bit about persuasion already. Deception, which, as many of you may know, is part of the FTC's authority for investigation in this space, is the planting of false beliefs. So it's a form of manipulation, but it actually really focuses on things that are not true, okay? Coercion is somewhat different. Coercion influences you by constraining your options. And so what happens is that, but through coercion, I get you to take a number of steps or a number of choices that gets you to where I want you to be and not necessarily where you would want to be. And I think we see this a lot today, especially in the consent space, where again, your options are really constrained. You may truly not want to have to share information in this context, but the UI is going to basically force you to do so in order for you to get access to whatever it is you're trying to get access to. Manipulation is a bit more specific. Manipulation is hidden influence. Okay, so this is trying to covertly influence your decision-making and really targeting people's vulnerabilities to get the outcome that the manipulator wants. And so in general, when we look across dark patterns, we see deception being, in my mind, deception is one of the easier areas because it's generally pretty simple, or not always simple, but at least you can often apparent to evaluate something as being true or not true. It's coercion and manipulation that ends up being kind of the tricky areas that we have to try to determine, because a lot of it is trying to understand what is the individual's best interest or what is their self-interest. And so one of the things we'll talk about at the end here is how to measure dark patterns and how to evaluate them and what to do about the gray areas. And this is where I think coercion and manipulation need to be part of the discussion, but it doesn't mean that it'll be necessarily a simple thing to actually evaluate. Okay, so going through a few examples. So this is an example of a privacy dark pattern, which we call contact harvesting. So essentially, it's trying to get you to give up information that you don't necessarily want to give up, in this case, your address book. And so these come from LinkedIn. LinkedIn, prior to being acquired by Microsoft, was doing a lot of this quite aggressively in like the 2014 timeframe. And so some of you may have experienced this directly, where you are able to skip. If you notice on these slides or on these images, there's always a capacity to skip the step, but they're really trying to push you towards disclosing your contacts. And if you're not paying attention, if you're not looking very closely, it's easy for you to just assume, oh, this is something I have to do as part of the process of signing up, when it's actually quite optional. You don't have to do it at all. Okay. Next, we have the dark pattern that we call guilt shaming or confirm shaming. And this essentially is kind of working on your sociability, meaning that it's trying to make you feel bad about turning the company down. And so the first one with the bear face, you know, basically they're giving you the choice of turning off ads or saying, I am a bad person. And, you know, you might laugh. I mean, it's pretty obvious, but I even find myself that sometimes when I turn these down, you know, having to read that, you know, are you sure you want to do this? Are you positive they want to do this type of thing, can often have this effect of making you rethink it for a moment and go, gosh, do I really want to? The middle example is from hotels.com. And I need to emphasize that as we go through these are all examples. They're real examples, but we're not necessarily making judgments on their legality. But I will say from my capacity and my experience, I would consider these potentially dark patterns. But the hotels.com example, no thanks, I want to pay full price rather than unlock secret prices. The last one is actually I took from BuzzFeed as part of the CCPA, and I apologize if I get all my CCPAs and CPRAs mixed up. It's quite an alphabet soup here in California. The CCPAs do not sell my personal information link. So I did some work this past summer and looking at how different companies implemented the do not sell notices. This one's from BuzzFeed. And one of the examples that we saw here is a tendency for companies to try to shame people into not opting out of selling their personal information, usually around focusing on the, you know, you really want to make things more relevant, you know, it's going to make it hard for us, please don't. I mean, there's just a lot of kind of guilt tripping around people trying to exercise those rights. Okay. So here is a few examples of deceptive dark patterns. So these are often in the e-commerce space, and generally they're focused on, again, kind of planting these false beliefs. And the idea here is this idea of scarcity. They're trying to work on your vulnerability to a scarce resource. And so it's also a form of what we call social proof, meaning if you see that other people are doing something, you're more likely to do it. And so the reason I will say these are deceptive is generally when these have been investigated, when developers have actually gone behind the code or researchers have gone and looked at the code, they're often, whether it's a countdown timer or what have you, they're often not connected to any actual real fact, meaning the countdown timer is artificial. Nothing's going to happen in 10 minutes when that countdown timer runs out. It'll just refresh and it'll give you another 10 minutes. In the cases of the examples I have on this page where 8 other people looked at your dates in the last 10 minutes, for example, potentially, but we don't have any proof that that's actually what's occurring on in reality. These things are really focused on trying to get you to make that decision and increase your stress and your sense of urgency so that you'll just go ahead and do it and not actually take the time to stop and think as to whether you want to actually make this decision. Okay. So another few from the privacy space. So what I'm calling kind of coercive and potentially confusing consent. And so the first one in blue, I think, is a really interesting example. This is from Adobe. And I included it because you have no other choice here but to accept. I believe we are seeing kind of fewer examples like this in the cookie space. This is for third-party cookies. And my understanding, and that is in part because our European regulators across the Atlantic have begun to crack down on cookie consents like these and basically said, you can't just tell people they have to accept, you have to actually give them options and not just focus on the accept. The other two on this page are also California examples from Do Not Sell. And I include them because in both cases, if you take the time to really try to unpack what's going on here, you might be able to figure it out. But for the most part, they're a bit confusing. The Huffington Post one at the bottom gives you a toggle. Do you agree or disagree? But agree or disagree to what exactly? Like what it's clicked to one side when you first land on the page, but you can't really tell what you're agreeing or disagreeing to. You'd actually have to kind of take the time to parse through this and try to figure out, am I agreeing to share information or not share information? It's not necessarily clear. The other example here for Warner Media, kind of the same thing. The toggle is selected when you arrive at the page, and it's unclear whether the state is that you are sharing your data with third parties or you're not sharing your data with third parties. And this one's even unlabeled, like, so it's hard to tell exactly what the toggle switch means, what state it's in when you arrive on this page. Okay. This one will probably be a little bit more controversial for some of you. And I mentioned on the last slide, the Adobe example, that we're not seeing these kind of bundled, or not bundled consent, but the fact that you have kind of a right to refuse or a right to kind of unbundle these things. These are all examples I collected yesterday from different sites. And this is bundled consent, where you're just by signing up and clicking continue or create account or get started, whatever the button might say, you have agreed to the terms of service and the privacy policy. And so this might be a good topic for us to discuss in the discussion phase. In that, what are the better options here? Should you be forced to go through the privacy policy in detail before you click the agree button or the continue button? Is that like the better outcome from a legal perspective? That might be one way of interpreting it. I would say from my design perspective, that's not optimal at all. And that I would actually suggest that we need to rethink how we even offer people the consent process and how we read privacy policies and so on, since we know that people generally don't do so. Okay. All right, so I'm done with the examples for now. We're going to talk about the California laws in particular, and then wrap up and move into our panel discussion. And so, as Stacy mentioned, California now has 2 kind of dark patterns regulations on the books as part of our new privacy laws. So the CPRA, which doesn't go into effect until 2022, has kind of a hybrid approach, meaning the CPRA contains a definition of dark patterns, which is here on this slide: a user interface designed or manipulated with the substantial effect, so based on an outcome, of subverting or impairing user autonomy, decision-making, or choice, as further defined by regulation. And then in the statute itself, it's very specific how to apply it in the CPRA context. It's focused very narrowly on consent. However, it is focused on consent for any data processing. And so I think the application of this in California may end up being quite broad and applying to many, many, many actors, although we'll see kind of what my colleagues have to say about that when we discuss this. The CCPA context is very recent. Those regulations were just approved last week, and they were refined specifically around this do not sell process that I've provided some examples of so far. And that's very narrowly tailored toward the business shall not use a method that is designed with the purpose or has a substantial effect of subverting or impairing consumers' choice to opt out. And so if you go through that regulation, there's a handful of examples of things that the Attorney General's office would not like to not see companies do. One example, for example, that I found in my own research was the practice of clicking on that link and then essentially being dumped into the middle of the privacy policy. And from that point, what I observed is that when that happened, in most cases, you had to scrounge around the privacy policy in order to find that opt-out link, rather than just taking you directly to an opt-out page or an opt-out form when you clicked on the link. And the Attorney General's office agreed that really there was no kind of justifiable reason for a company to do that. That it made much more sense to make it an easy flow rather than forcing people to have to hunt around for those links once they clicked on the do not sell. Okay. So this is my last slide, but I'm going to spend a couple minutes on this before we move on. So what are some of the takeaways for regulators in this space? So first question, is the current FTC Section 5 authority sufficient to address dark patterns? Or do we need an expanded authority here? So again, as many of you may know, and as we discussed already, the FTC can act against unfairness and deception. And so the question, as I have seen it, is whether manipulation, coercion, those types of dark patterns, do we think that falls under the deception authority? Does it fall under unfairness, or do we need kind of an additional prong in order for the FTC to reliably be able to go after dark patterns in this space. Another question, which I haven't talked about, but I want to tee this up in case we have time, is how to measure these things. So the empirical considerations, how do we measure them and who does the measuring? That's a piece that I think a lot of policymakers probably aren't thinking about, but from my standpoint as a researcher, this is really crucial. And in part, it's because the kind of research community in this space is still very small, and there hasn't really been a lot of kind of debate on kind of what is the right way to approach these things. It might be that folks in the practitioner space who have a lot more hands-on experience seeing these things in the wild have thought more about it. But from the research point of view, I think it's still really open as to like, how are we going to evaluate? What is the best standard procedures, for example, for evaluating a dark pattern? And so from my perspective, that is still very much up in the air, totally resolvable, but up in the air. And who should do this type of work, for example? Again, also identifying dark patterns versus gray patterns. And so this is going to be a really thorny issue, I think, because truly dark patterns are generally not as difficult to spot and not as difficult to evaluate. The cases that I have personally worked on in the past have been often on things that I think are generally uncontestably dark. And so I think one of the key aspects to this is if a business is relying on that dark pattern in order to turn a profit, and you remove the dark pattern and their business model fails, like that's usually a pretty clear sign that the pattern was very dark, and that curing that deception or curing the dark pattern results in the fact that the business fails. But we're more likely to see things in the gray areas, companies trying to come up against those limits, but not quite cross that line from persuading, but maybe potentially manipulating and coercing, but not maybe the outright things where you look at it and you can say, oh, I'm sure that people aren't understanding this, or they're not being able to actually fulfill what they want to do. One of the things that we'll talk about in a second are this question of neutral designs. Could we have a neutral design? Is this a realistic option? And is it enforceable? And is this something that we should have at decision points, for example? So earlier I mentioned consumer protection laws and those cooling off periods. I think you could consider a very similar model in this decisions point space. So whenever a consumer is presented with a decision, maybe we have laws that really focus on making as neutral of a design as possible, but that presupposes that we can come to an agreement on what does neutral mean. Does it just mean it's not persuasive? Does it mean it's a gray screen? Like, what does that mean? So I think that's still an open area that's open for debate. Couple more. What does this mean for privacy by design? Like, privacy by design is something obviously that's still kind of emergent and growing, although we have, the FTC relies on privacy by design in their guidance. But what is designing for dark patterns, for anti-patterns, or light patterns, or whatever we want to call this space? How does that implicate privacy by design? How do we work that into the kind of the privacy by design toolkit for the design side of the house? And one of the last ones here, how does the CPRA's effect standard differ from a potential intent standard? And so in the paper that Stacy mentioned at the introduction that I'm working on, we try to really decompose this effect versus intent question. We think it's really key that we focus on outcomes and be able to measure those outcomes. But what does that mean in the regulatory space? What's the most kind of measurable outcome and the most enforceable outcome here? All right, so we're going to take a quick poll, audience poll, and then we will move from this into our panel discussion. And so, here are the instructions for the poll. And let me move this off my screen. Okay, so I just talked a little bit about neutral design. So this idea that maybe at these different decision points we have a neutral space, meaning that you couldn't have a design that's unduly persuasive or that coerces you into making one choice versus another. So I found a very simple example of your ability to accept or decline the terms of service. And so I get to see the answers as people are voting. Is this a neutral design? So that's my question to you all. So would you consider this not manipulative or not coercive or even potentially not persuasive? And so I see the votes coming in, and so we'll we'll move to, I'll wait just another moment, but we'll start discussing that in just a minute. But thanks for your time, and I really look forward to hearing your questions. And I will go ahead and stop sharing my screen at this point. Actually, I'll wait one more second. Looks like there's a few more people voting. Again, so I'll just repeat the question. Is this a neutral design? So again, is it something that's not manipulative, not coercive, or potentially even not persuasive? Or would you consider this non-neutral in some way? Great. Okay. Stacy, I'll hand it back over to you for the moment. Oh, and let me, actually, I apologize. I'm going to share my screen again to advance us to our next slide, which I just lost track of. Okay. Oh my goodness.
That's okay. That's
I'm
okay,
sorry,
Jen. It was just
my order was my order was out. I apologize. Okay.
Awesome. It was just the names of our panelists in case people wanted to get in touch, I think was the slide we had.
Right. Actually, but first, though, did you want to take any questions at this point, or shall I go ahead and advance us along?
Yeah. So we have a ton of great questions in the Q&A. Most of them are pretty broad, so I want to reserve them for our discussants. But if anyone at this point has a specific question for Jen about the presentation, we could certainly take that now. And so there's only one maybe that I see that I'll direct to you, Jen, and then we'll continue, which is well, actually, I changed my mind. Actually, I think it's good for the whole group. Do we have the results of the poll? Are those available? Can people see them? There we go.
Interesting. Okay, so we have 33% of those of you who voted said that yes, it's a neutral design. Interestingly, over half, 54% said no, it's not a neutral design, and 13% said they weren't sure.
All right. So I think that's a good way to lead us off into my first question, which is going to be, is neutral design even possible? But first, let me just introduce our other guests today. So thank you so much, Jen. Tons of things to think about from your presentation. And let me loop in our other guest experts today, because we're very fortunate to be joined by two others. Mihir Shirsagar. Mihir is, Mihir works at Princeton University and runs CITP's Interdisciplinary Technology Policy Clinic. So he's the clinic director. He works with students that are public interest-minded technologists, and runs that clinic at Princeton Center for Information Technology Policy. And Mihir, if you want to add anything to that, please feel welcome. So you're working with public interest technologist students. And Tanya Forsythe is one of the country's top privacy and data security lawyers. She is the chair of the Privacy and Data Security Group and a supervising partner at the LA office at, whoops.
Oh, sorry.
Sorry, the poll's getting away. At Frankfurt Kernet. Tanya, and if there's anything else you want to add to that, please feel welcome. But I think what people should know about you is that you are actively involved in advising business clients on CCPA and CPRA compliance, even though CPRA, of course, won't come into effect for a few years. So you're thinking about this from a compliance perspective, and here you're thinking about that too, and also thinking about it from a design perspective. So let me ask all of you, maybe we'll start with you, Mihir. What do you think about this poll, and is neutral design possible?
It's a great question, and I should say I have a prior background. I worked for the New York AG's office for many years, and was a litigator there, and before I came to Princeton. So the way it's a great question. The way I would sort of evaluate it is neutral in what context, and so in the context of what this example shows the user, the way I would sort of analyze it is to see how is the information that's presented to the user, is it shaded in any way that benefits the service over that of the user? And why is that being done? And I would say that, I'm curious about how my fellow panelists would view it, and it's very much a matter of judgment. But the accept button is highlighted in green. There's a sense in which that is already the pre-selected option, and I would be curious in the A/B tests for the design if a company would be able to run it with the other way, whether that if you had the decline more prominently highlighted, would that change people's opinions? And in a neutral pattern, you would expect, or if you thought that people were making free and fair decisions, they would click on those equally, regardless of sort of how the design is presented. I suspect that there's a good reason why the accept is shaded the way it is.
And I'm happy to jump in. From my perspective, it sort of takes one problem and steers us into another, which is that practitioners have been trying for years to get away from the model where we require somebody to scroll through a set of terms and read through the fine print. And so I don't know whether we want to call that a dark pattern or not. So if I was allowed to vote, I wasn't, I would have said uncertain, because to me, forcing a consumer to read through the fine print in and of itself creates a manipulative situation, which we've been trying to get away from. So ironically, I would hate to see us in our efforts to avoid dark patterns, what we're now calling dark patterns, move in the direction of throwing more jargon at consumers that they don't understand. So that's my concern with it.
And I will kind of wrap up on that by saying, yeah, I hope the either or is not kind of the status quo, or we bombard you with fine print. I would love to see a different option, but I will say, I worked on an experiment a number of years ago where we were trying to build a quote unquote neutral interface. And one of the kind of results I took away from that was that people look for trust markers. They look for ways to kind of trust you beyond kind of what is immediately on the screen. And so I just want to say that I don't think we can sit here and argue about, buttons and whether buttons, like you can imagine, maybe we create a completely grayed out interface that is as quote unquote neutral as possible and put that in front of people. But I think one of the lessons I learned from doing a little bit of work in the space was that it's not always that simple, that people are going to look for other things to potentially try to find an assurance or some way to kind of understand whether they can trust the site in general. And so it won't, even though we kind of try to make those interfaces less manipulative or coercive, we still have to think about the larger context in which they operate. And so just to say that I don't think that simply decreeing that all kind of decision points should be grayed out, for example, will be the simple solution to this problem. Regrettably, it's going to be more complicated, I think, than we anticipate.
I think I agree with that. And I'd be pretty comfortable going on record saying I'm skeptical that neutral design is ever possible. I think there's always context, even in the kind of situation that Jen, that you're describing. It's always the context of what the decision is, where that person's coming from, what the choices are, and what influences those choices. Which maybe takes us to Katerina's question, which I'll try to paraphrase a little bit. And if I get it wrong, hopefully she'll jump in. Let me just say 2 ways, again, as a reminder, 2 ways to ask questions in this webinar. You can put it in the Q&A. If you prefer, we are recording, but if you prefer, feel free to raise your hand and we'll unmute you and you can say your question verbally, jump right in. So I'll try to, I will try to paraphrase Katerina's question, which is, aren't these definitions all a little bit too narrow? What about personalized design throughout the web, basically with everything that we interact with? There is A/B testing, there's testing around effectiveness, there's discussion about what it means to have exploitation of people's individual vulnerabilities. In a way, can't you classify all online advertising as a as a dark pattern? So I'll put that out there just to be kind of provocative and get your reaction.
Yeah, I'm if it's okay, I'll kind of jump into the fray here. From a practical point of view, I think we have a fundamental problem, which is advertising is manipulative. all advertising is manipulative. The point of advertising is to persuade. Let's use the word persuade. The point of advertising is to persuade people to buy something. And not just online, you know, historically from the beginning of time, right? Okay, so I do think we have to be careful, and I know Dr. King was distinguishing between the intent issue and the effect issue, which I do think is an important thing for us to be looking at and considering whether the emphasis on intent is as important as it may appear to be based on some of the definitions. You know, I do interpret the definition of dark patterns in the CPRA to be focused on intent and not just effect. There is the word effect in there, but you have to have, in order to get there, you have to have some sort of intent to manipulate or to design it that way. I think that if we start to look at anything online that is designed to persuade someone to buy something as a dark pattern, we're in trouble, because we're going to effectively suggest that all marketing and all advertising is a dark pattern. And, you know, am I one to judge whether that's true or not? Maybe that's always been the case, right? But I don't think that's the goal here. I think the goal here is, again, to prevent discrimination, prevent, you know, things that are going on in a way that is not obvious to the consumer or the end user, that manipulates in a dangerous way, in a somehow unacceptable way, prevents them from making a meaningful choice about what is being presented to them, where they can't effectively make that choice. Then we run up against the next problem, which is every population is different. Some populations are more sensitive than others. Someone raised children, of course it's more concerning when it comes to children. I think about the older generations. I think about my parents and the kinds of things that confuse them when they're online, which are much more easily fall into the trap of not understanding what's being presented to them, not because they're not smart, but because they're not used to these interfaces still, than those of us who have been living online, right, for a long time. And so I worry very much that a one-size-fits-all definition of what is a dark pattern could be a never-ending cycle where we're just not able to comply properly.
Mihir, did you want to jump in? I saw you nodding, and I'm curious in particular what you think about this question of defining a dark pattern based on the designer's intent or the company's intent versus some other.
The effect test, and you know, on that point, intent, I think, does play an important role, sort of in an enforcement decision, right? If as an enforcement lawyer, if you were able to show up and say, look, this was, you know, completely unintended. We wanted to present this information to the benefit of the customer, but somehow we messed up, and it's not that way. I think that will play heavily in an enforcement decision. But just stepping back for a second, I think it's a great question that Tanya is raising about, you know, how is it that is all advertising just in a persuasion? And so how do we draw lines here? And I think it's sort of helpful when you're thinking about it to go back to the early design of the internet, right? Where we thought that, look, things are going to be more transparent. People are going to make decisions based on all the available information, and that consumers were going to be in parity with the sellers and the services that were providing services to them, and that there was this idea of a parity between the user and the service. And I think what we're seeing with, you know, data collection and with the ability for the services to know a lot more about their consumers, and consumers to know less about what the data service is doing with their information, there's a way for the data service to exploit that inequity. And I think that's where a lot of the concerns about dark patterns are coming around, is where there's a concern that there's an undue influence, if you will, that the service has in helping design structures so that, you know, children can get manipulated in particular ways, or older adults, or particular groups of people. And I think in the background, there's always this concern that, you know, there'll be the ultimate profiling of ads, where it's sort of hyper-personalized. And I'm sure, Jen, you've looked at this, but we're always hunting for measuring whether this is happening in the real world, and I haven't come across that so far. But I think it's an ever-present concern, and it is always something to think about.
And I'll just add that I mean, I actually agree with both of you a lot, and I think that at least initially, the way I've been thinking about this space is to focus on contexts and kind of these narrow definitions to some extent. So really trying to look at areas of concern, and I've called them touch points earlier. I do think that we need to think about kind of these global touch points where kind of all users kind of end up filtering through like a single portal. And that's where maybe we should consider thinking about the research and the regulation. And so from that standpoint, I actually have liked kind of what I've seen with the two California laws, because it has been very narrow and focused on a very particular context. And I really agree with all the kind of issues that Tanya raised around, because I think this is very understudied and underappreciated in the broader space around things like privacy policies, where we haven't done the research. And I say we, I mean, the community of researchers, not just myself, on understanding how people from different languages, different education levels, different ages, how they really understand these consent processes, for example. Like, that world is just totally untouched. And instead, we filter everybody through this kind of single portal. And so if we're going to continue to do that, then I think that raises the question as to whether we need to do the due diligence of understanding how well those portals work for communities that are more vulnerable. That way, I think we leave behind today completely. But this bigger question of like where we draw the line between all advertising and whether all advertising is kind of manipulation, and I think you could take that point of view, but I also think that there's other questions implicated in the kind of targeting and information collection that we might want to separate out from just this bigger question of what's manipulative, because I think there's a real kind of power and unfairness issue around how data is collected that is kind of implicated in dark patterns, but is maybe something we should deal with separately and not just focus on the UI.
Yeah, sorry, Stacy, if you want to take us to another question, that's fine. I was gonna throw something else in.
Yeah, please.
Okay. This is sort of in line and sort of related. I want to focus a little bit on CPRA, and because we've been talking about it, and that it is focused. So first of all, with CCPA, I completely agree with everything that's been said already, which is it is very narrowly focused on the do not sell presentation. And in my mind, it felt like a little bit of an after the fact thing that they started saying it was about dark patterns, right? What it really is it makes very clear. In my world, this all goes back to what we've called clear and conspicuous for years, right? I mean, even if you look at CalOPA, the California Online Privacy Protection Act from like 2003 that requires a privacy policy, there's language about it needing to be clear and conspicuous. And I see it as similar. In other words, when I talk to clients about how do not sell has to be presented, I'm saying clear and conspicuous and not requiring somebody to go searching here and there and everywhere. But now we're saying, okay, it's not avoid dark pattern. Okay, fine, right? That's fine. With CPRA, what it says is you can't design or manipulate such that you have that substantial effect. So the verbs are design or manipulate, right? Manipulate obviously is a stronger word than design. But also importantly, it relates to the definition of consent in CPRA, and that's all it relates to. That's all. So the only place where the definition of consent is relevant in the CPRA is, and Stacy, you brought it up earlier at the beginning of the presentation, is in situations where a person, CPRA really doesn't require affirmative consent in most situations, only with financial incentives, which we already know you have to have affirmative consent, so you can't do it there, with opting back in after an opt-out, and with kids, effectively, right? That's it. So I actually don't think the CPRA's incorporation of the dark patterns language is going to have a very widespread effect on a lot of company behavior, because the circumstances in which you have to get an explicit opt-in are so narrow. And I don't think the law explicitly mandates that you avoid those dark patterns in any situation other than where you have to get that quote consent where it comes up in the law. But we'll see how that plays itself out, and whether the AG will be more aggressive, or I should say the new agency really will be more aggressive in enforcing that. And my last note was, I do think there are some things that clearly stand out, right? And not just this sort of broad, like, is everything manipulative? I don't question at all some of the examples that Dr. King put up there, and also that I'm going to throw one out that I have in mind that may create some controversy, I don't know. But we have been told that Facebook, and they may already be doing this, I don't know if they've already started doing it, if there's just a plan, is going to throw up a screen before the new Apple requirement for to actually affirmatively allow third-party tracking. We've been told, Facebook has publicly said they're going to put up a screen that tries to convince people why they should agree to that. In my mind, now, is it manipulative? Is it dark? Or is it really just in your face, like, we're going to tell you this is why this is good for you and you have to trust us because we're Facebook and whatever? That to me raises questions on that front.
So on the CPRA issue, I think, yeah, that was my sense too. And, you know, of course, because you're working with companies complying with it or building towards compliance with it. Where I've seen it have an influence is in other states that pick up that same language and use it in contexts where it does actually matter or mean something, like in the Washington Privacy Act, where it's been kind of just picked up, transposed onto a state bill that does require affirmative consent for the collection and use of certain types of data, sensitive data in that case. So, you know, still for those wondering, like, why are we talking about the definitions, right? Because they get picked up and then used across the United States. We've got a couple of people who have had their hands up for a little while. I want to bounce to one of them with the understanding that if she, you know, maybe she wanted to talk 5 minutes ago and no longer. So I'm going to allow Quenisha to jump in if she wishes. And if not, I think I've got the question down here.
Hi, can you hear me okay?
Hi.
Hi.
I can hear you.
Yeah, with the presentation, one of the questions that popped up in my mind was that I am based here in Indianapolis, Indiana, and I know the law has passed in California, but I was just curious as to the companies, if they adhere to having the website in California or their company, would they actually adhere to different states since it's not implemented here in Indiana just yet? So that was one of my main concerns as far as like, okay, well, I have a website here for California. There's other IP addresses in different states. So will there be different websites outside of, the California website or, whatever business that they may have? Would that affect as far as the dark patterns, how they,
Sorry.
I can take a stab at that, and then I bet Tanya will also have an answer too. Just in the research I did on the do not sell link, which is based on the California law, I had students working with me both in California and different states, and we noticed that most sites were doing what's called IP filtering. So if you were coming outside of California, you didn't see that link, and you didn't see even potentially that part of the privacy policy, or didn't have access to the tools for making those requests. In some cases, they didn't filter by IP, but they wanted you to attest or give your address and basically prove that you were in California. So unlike what I think we've seen with the GDPR, where some of the big companies have made GDPR tools available in the US, I haven't seen that happening in my narrow experience with the California law and companies who maybe have multi-state businesses, but have a website that they're offering in California.
So this is again somewhat anecdotal because it's based primarily on my own experience advising clients, right? And I would say that the vast majority of organizations that we have seen doing CCPA compliance as well as preparing for CPRA are not distinguishing between, you know, whether someone is showing up from California or not. In part because, remember, unlike GDPR, GDPR is based on where you're physically located, if you're physically located in the EU, and so you can use an IP address as a proxy if you want to do that. California is based on residency. Applicability is based on whether the consumer is a California resident, meaning they spend the majority, essentially the majority of their time, like it's a tax definition. Most companies actually don't know if someone is a California tax resident. That's the reality of the situation. And so you can try to use an IP address as a proxy, although I can't speak to whether I think the AG will accept that interpretation or not. I know there are some companies who are only making a do not sell link available based on someone's IP address coming from California. And I don't think it's been tested yet. It certainly hasn't been tested yet. We don't know if that's going to be considered to be compliant or not. But most companies I know, because they don't know if someone's a California resident or not, they don't have a separate California website. They're not treating people differently. And remember, for a do not sell request, unlike a delete or an access request, you're not supposed to ask for verification. It's not a requirement. You don't have to verify that somebody is a California resident to honor a do not sell request. So I actually think that if you are implementing these new rules around dark patterns or avoiding dark patterns, it would be next to impossible to try to distinguish, you know, whether someone is actually a California resident or not.
All right, thanks. And on that note, since we mentioned the GDPR, I should note that we at FPF are very interested in doing future convenings on this topic. One of the convenings will certainly be a full hour or 2 hours on how the EU is addressing this issue of design. Two things to note about EU law. One is that the GDPR has an affirmative obligation of privacy by design. And I saw some folks here asking for resources on privacy by design, so we'll maybe send some of that out in the follow-up. And the other is that in the GDPR, the definition of affirmative consent itself is written in a way that sets a fairly high standard. And it's worth mentioning because that high standard, or the language from that standard, has been adopted in other places in the United States, specifically in the Virginia privacy law that just passed into law recently. So that definition is specific, freely given, informed, and unambiguous. And there's some case law in the EU applying this to things that kind of look like manipulative or coercive design. So major area of focus, super, super interesting. And I think we'll return to it at a future date just to give it the attention that it deserves, unless anyone here wants to jump in on GDPR. So we'll note that, and maybe keep it in the context of maybe the Virginia privacy law. Do we think it'll be possible, even without a definition of dark patterns, specifically in the Virginia law, to apply that law's standard of freely given, specific, informed, and unambiguous consent to address some of these issues? My sense is yes. Curious what others think.
So I'll jump in there. I think that's right. I mean, I think that you know, dark patterns in some ways, and this sort of presages the question that came before about, you know, to what extent is it adding something beyond the unfair and deceptive language that has existed for a long time in states and federal law. And I think that the freely given consent would definitely incorporate some elements of you know, deceptive interfaces and so forth. So I think really the question is sort of where does it not meet it? And it would be on areas which I think you'd have to think of examples where the manipulation is close enough to the line, but where maybe, and this is the paper that we were talking about, where we're trying to think about what are the collective problems. So where, let's say, a responsible set of companies wanted to present information in a certain way that was standardized so that everyone knew and understood what was happening. And you could see that some other rogue companies would present it differently. And you can imagine a state regulator or a federal regulator saying, no, let's all present information the same way, so that minimizes the risk of confusion for the consumers.
on Virginia, I'll just add, like, I actually am not worried about Virginia and other states that have an explicit consent trigger. I'm closer to GDPR and in Virginia's case for sensitive information, right? I actually think if you make it a requirement to get explicit consent, and maybe I don't know why I think of it this way, but I actually think no matter what, that's going to force an organization to do something that's more explicit and more upfront than if it's an opt-out. Even if the opt-out cannot use a dark pattern, I still think that having an explicit consent standard is going to be something where it's much more challenging for an organization to try to engage in a dark pattern there. I just think inherently an opt-in is more likely to avoid that problem, even if you don't explicitly incorporate that definition.
I think I agree with that. We're reaching sort of the top of the hour and a half, and with big thanks to those who are still with us and still engaging. This is awesome conversation. I think we'll take maybe 2 more questions. I've got one from Ray Castillo, who's had his hand up for a while. So Ray, if you're still hanging out and would like to ask your question, we'll unmute you. And then there's one in the Q&A that I'd like to get to. Although panelists, you may want to take a look as well and see if there's a question there that you'd like to answer. And I think I saw Ray dropped off. So let me switch now to Sarah. Hi, Sarah. If you'd like to ask your question, you can be live if you want to now. And if not, we'll go on to another one. That's okay. All right, this is my fault for waiting too long to get to people's questions. All right, let me get to the one that's been in the Q&A for a while that I've thought is particularly interesting from Jeff. Okay, should we consider laws or regulatory approaches that require reporting on click-through, opt-in, and opt-out percentages or numbers per design? And I'm going to assume that Jeff means either some kind of public reporting or perhaps some form of reporting to a regulatory agency, perhaps. Maybe there's a difference there. But reporting, what would that look like? Does a high opt-in percentage mean that the design is good, or does it mean that the design is bad?
I've been wondering about this question as well, because my suspicion and anecdotal conversations I've had with colleagues who work at companies is that if you look at the numbers of who clicks on these things today, broadly, consent, privacy policies, tosses, I mean, they're very, very, very low. But does engagement translate to what? Comprehension? Should a company have like 50% of their customers click through on a privacy policy? I would say not as they're written today. No, that's not going to be meaningful in any way. But I think it's a really interesting area because I have wondered if we could get companies to do a form of this type of reporting as kind of a first step in terms of trying to come to some agreement on what we should do in this space, the same way we've seen them with NSA, letters and so on, in terms of just trying to, show us what's going on in the field so that we can have a real discussion. But I wouldn't necessarily say that, at least today, privacy policies are so challenging for people to read that simply getting people to click through them, to me, is not like a baseline measure of that we've improved anything.
Yeah, I would add that there's sort of a distinction between, I think we're focused on sort of why the consent is broken, as we've been going, multiple times. I think consent is broken for privacy, right? And that's just, you need some alternative to consent, or some other kind of mechanism to ensure that people's rights are being respected. And then there's a separate question of design. And I feel like on the design question, I think it is useful to have some numbers. It is useful to be able to compare across industries. It would be interesting to say, is a travel website getting a different rate than some other kind of website? And within different companies, I think it'll be useful, just wearing my regulatory hat, if you had that kind of information to make a decision about who are the bad actors, where do I get a sense that something's going wrong in this process? And I think one point that, picking up from a question that Colin Gray asked, that's important to this is that we look at it not just in the context of one design decision, but we look at it in the context of the holistic. It's the whole website, and it's also aspects of how it works over time and how do people get affected over time. I think both those, these are hard research problems to develop data to collect the data for, but I think it's important to have that in mind, that how people see the website as a whole and how they view it over time is also important to the analysis.
I agree with everything that's been said, actually. I think that numbers could be very misleading, and that because nobody reads a lot of these things, it's hard to know if someone's clicking through, how meaningful that is. That being said, I know a lot of companies would love the benefit of some real information out there about rates of opt-in versus opt-out, because I get asked questions about that all the time in various contexts, and we have so little information, right? I can always just say, oh, I'm just a lawyer, I don't know anything about the actual data, right? But it would be nice to have some real data about that, just to be able to measure and get some sense. And there are other contexts legally where we could look. The one where I feel like, I don't know if the word dark pattern has been used officially in this context or not. I think it has, but maybe not in the actual laws. The auto renewal laws, right? The auto renewal stuff is a place where, because there's already been legislation in a lot of states, and in fact, in some states, pretty potential significant liability, including class actions with statutory damages if you don't get that right, that could help us measure, maybe if we looked at how that's evolved with new laws and preventing companies from trying to trick people into auto renewals, what we've seen there. I don't know.
Okay, yeah, I think that's a good set of answers for that question. I can share my own experience has been that I'm never quite sure what to make of data on opt-in and opt-out rights, which are sometimes shared, for example, for purposes of getting investment, or I see them shared sometimes at trade conferences as occasionally evidence that a consent model is good or effective if it has high opt-in numbers, which could, of course, cut either way, right? Okay, so I don't think we will get to all of the questions. These are all really, really excellent. We can maybe do some individual follow-up. I think we put at least Jen's and my email address up on a slide earlier, and you can get those too just by emailing the info@FPF email box if you'd like to get in touch with us. I notice, David, you've got a great question in the chat as well, but maybe deserving of a longer conversation, so sort of highlighting the challenges about take it or leave it approaches. And this comes up often in conversations about whether laws should allow room for bona fide loyalty programs, and what the limits of consent are when it comes to purely advertising driven business models. And yeah, my sense is that that's a much longer conversation, but certainly something worth talking about. If that's the whole business model and the choice for a publisher is advertise on their site or not have a website, right? Perhaps the right answer is something that doesn't rely on opt-in, but is more limited in scope, right? And is there anything anybody wants to jump in sort of off the bat on that question, to take it or leave it business models? Totally unacceptable, room within limits?
The only thing I'm going to say, and I do think it's like it's like an hour long, it's a 2 hour long, like you can't go there, but the whole balance between if somebody doesn't want to consent to certain kinds of, for example, tracking, is it appropriate to suggest that they should pay a fee for something or have to not use it? And depending on who you talk to about California, different people interpret the financial incentives provisions different ways on that front. But I think that is a part of that discussion. Is it really take it or leave it? If you're saying you can you know, agree to certain kinds of tracking, or you can pay a little more, or maybe you get a service that doesn't have all the bells and whistles, but you still get the core of it, right? I think we have to provide some allowance for that online, because otherwise I do fear that you're taking things away from consumers if you don't offer them those kinds of choices, even if it might sometimes be seen as take it or leave it, but it can go too far, for sure.
I would add that I probably fall more on the side of saying, hey, you need to give people options. And there's just so many contexts right now where I feel like we often talk about these things in the abstract as if all of the choices are either equivalent or that they're all kind of online shopping. Like, oh, I can just choose whether I'm going to buy shoes from this retailer or that retailer. When, you know, I'm thinking of cases where, for example, as a parent, you know, my school district says, here, you have to download this app. It's the only way you can communicate with our teachers. Guess what? It's also a free app that we didn't pay for. And, you know, we're essentially paying with your students' information. Like those contexts I have a real problem with. And so I think we need to really highlight the fact that I just feel like there's this almost myth making that we often engage when we still talk about alternatives online, where it really comes up like, oh, well, you know, it's really just about these kind of choices we have with consumerism. And in so many instances, it's not. It's, you know, fundamental. I either get my students' grades or I don't. And you know, the fact that the school decided to use a free service and didn't pay for it ends up sticking kind of all of us with that bill, if you want to put it that way.
All right, I think leaving off on a big open-ended question for a future discussion is a good place to stop. I want to just say thank you to Mihira, Tanya, and Dr. King for joining today, and especially Jen, to you for your amazing presentation on sort of the history and context of dark patterns. We're very interested in this topic at FPF. We're going to continue focusing on it. This is the first future convenings that you'll see from us. Specifically, two things we'd like to dive more deeply into are EU law and the GDPR, and some context around dark patterns in specific situations or contexts, like with children when it comes to youth and education. Very, very fascinating. Final words from you, Mihir, Tanya, or Jen before we wrap up?
Thanks for having me.
Thanks.
Thank you all so much for joining. Okay, we'll follow up with us. Please stay in touch, everyone. Join our newsletter, join our listservs, and you'll hear more from us on this. Thanks, everyone. Have a great day.